Please, Your Lordship. So I beg to mention item number 6. I've informed the other side. After 3 weeks, I had sought on the last occasion. I had sought time regarding some clarification from the petitioner. He had suggested additional changes into the rejoinder, my lord. We have not received proper instructions yet.
Rejoinder is to be filed.
Yes, Your Honor. Yes, my lord.
This is posted for hearing.
Posted for hearing, yes. It was posted for hearing, but rejoinder is still due.
How long?
After 3 weeks, my lord.
3 weeks.
3 weeks.
Mr. Naira Counsel for the petitioner has sought for accommodation on the ground that the rejoinder which is to be filed on behalf of the petitioner could not be done so today. Mr. S.P. Wanta, Senior Counsel, appearing for the respondent number.
Respondent number?
Number what?
3 and 4.
3 and 4.
3.
3 and 4. Union is for 1 and 2.
3 and 4 has made no objection to the premium. Mr. Counsel, appearing for respondent 1 and 2, has also expressed no objection to prayer. As prayed for, this is matter after 3 weeks.
Much.
Your Lordship, I beg to mention item number 3 in hearing list. The conducting counsels have some personal difficulties.
What's number 3?
Item number 3.
Lordship, we are for the petitioner. Lordship, we can do our, because NHRM is not really a necessary party. It's the Deputy Commissioner who will determine the entire thing. So let us do our hearing today, Lordship.
You are appearing for?
For respondent number 3 on behalf of P. Bhattacharjee.
Because Lordship gave the impression that we will finish it today. So we'll finish it. I'll take half an hour maximum. We may be allowed to do our part at least.
Yes. We'll see. We'll hear the appellant. You will be there. You can take down notes.
Okay.
And perhaps you can reply in the next date.
Next date. Obliged.
List item number 1. We still require some more time to file the application. The respondent for 6, 8, 11, 13, 16, 19, 22, 23, 26, 27, 29 to 31, 35.
My lord, this is with regard to, my lord, here we have around 35 respondent.
Yes, my lord.
5 is stayed, 1 to 5. So, my lord, the remaining respondent, my lord, most of them has retired. That is what that has been brought through submission, my lord, to the record of this court. So, lordship, in one of the occasions, since this matter has been adjourned for a very long time, so, my lord, so in order to bring the actual fact, the present situation, lordship has has on one of the occasion said, why not those particular people who have retired, who does not want to contest, be brought into record and some miscase be filed, and so that they can be struck out from the particular case, my lord. So that is what my friend is mentioning, my lord.
And some respondents also, my lord, it seems that they've passed away also, my lord. So the counsel for the respondent on the last occasion, she informed us that she'll give us the details of those respondents who have passed away and will move an application for striking off, my lord.
The petitioner himself has also retired, my lord. It's been now 2 years.
Who's appearing for the
Private respondent is represented by Mr. Karmoplang, my lord. Kit Karmoplang, my lord. Kit Bok.
Miss Pasa?
Yes, my lord, with Ms. Pasa.
So we require just that information from the counsel for the respondents, my lord. That's all, my lord.
Mr. Land Counsel for the petitioner has submitted that it has come to the knowledge of the petitioner that some of the private respondents have since retired. Others and some have also expired. However, complete and specific details of the same could not be produced before this court today. It is prayed that sometime may be allowed for the petitioner for the learned counsel to seek instructions and to make necessary and to take necessary steps. As prayed for, this is matter of the 3 weeks.
Highly obliged, my lord.
Item number 3.
May it please the lordship, this is against the reference court order. On the other occasion, we had pointed out to your lordship that the award was not there. Now the government advocate has furnished us a copy of the award statement. Lordship, that's the award statement.
Should this form part of the records?
I'm not sure if that's part of the trial court records, but this may form part of the record.
But you have preferred the appeal.
Lordship,
You have preferred the appeal. You are the appellant.
I've got a copy.
You are the appellant.
Yes.
And this is also, should be part of your pleadings.
But we never had that award on records. So this is for the first time that I got the award. All we got was a statement of the amount which is payable to us. So last occasion when I pointed out before your lordship that the award itself is not there, not even in the lower court records, that was the time lordship had directed the government advocate to look whether the award is actually there. He looked and now he gives us an award statement. This is the first time we have seen this award statement, lordship. This was never given to us at no point of time.
Was it necessary for this award to be, copy of the award to be?
Just one thing, I've gone through the memo of appeal. There is no whisper about the fact that this award statement was never given to them. This is a very vital issue.
Lordship.
Oral submissions are being made today that this was never supplied to them. But there is no whisper anywhere in the pleadings. I just wanted to confirm. Your lordships may go through the entire pleadings in the memo of appeal. Nowhere does it say that they were not supplied with a copy of the award. If that is the case, why would they prefer section 18?
Lordship, section 18 was preferred because the award statement was given to us and we were given the money as per that which we took under protest. Against that we passed and preferred in section 18, which was heard. Now this appeal arises out of the judgment in the reference reference case. So, and this is when that was pointed out, Lordship had put a question, what were the reasons given in the award? So, we said no award is given to us. Then we don't find the award also in the record. Then this is what they furnished this award statement. Strangely enough, even this award statement, it's not really an award in the eye of the law. Lordship, it just says when was the notification issued, date of declaration, in the area, the amount for land compensation, amount for trees, buildings, crops, etc. Total amount payable, that's it. How they arrived at this figure, the basis, that it is absolutely silent.
Oh, but is you see, are you privy to such a calculation?
No, I'm not.
Because you see, they will make the assessment
Yes.
based on whatever metrics they use.
But that in the award should reflect that, Lordship. The award should reflect that.
How
but
it was
yes, yes, that this is the rate, this is the market value, this is what, this is the tree, these many trees are there, this is what. Award doesn't reflect anything. It's a composite award for everyone, which is given with only the statement. And what we were given our part of the entitlement as per this award, and we accepted that under protest. For that, Lordship, the land value was taken as 240 rupees per square.
This is the award for the total.
Yes, it's a composite award.
Composite.
It's not a case that they have challenged it by saying that this award does not hold good in the eyes of law. No challenge was made. In fact, they preferred a Section 18 application asking for enhancement. It wasn't their case that this does not stand or that they want an individual award.
We have, but this award is no award in the eye of law. Lordship, I don't have to say that. If something is bad in law, it's bad in law, whether I say it or not.
You see, if it is not brought on record,
Yes.
not challenge as he has said it, then what do we do?
No, now since I've come on his reference
At this point
application,
of time.
I have challenged. I'm just pointing out to your Lordship, this is the mechanical way in which things are done. I'm just pointing out that, Lordship. I'm not asking your Lordship to strike down, set aside the award at all. I mean, the form, enhancement is a different
there is
matter.
no question.
There's no question now.
As far as
Now,
the award is concerned.
Lordship, what has happened? After
But
the-
what you rightly said is the court had made a query as to the basis of the reference vis-a-vis the award.
yes,
So there is no award on record. You have not brought it,
we didn't have it.
and
They
neither
have,
had
the court had asked the government advocate to produce it, and if the government advocate couldn't have produced it, Lordship, the entire matter would have gone back to the deputy commissioner again to try afresh, because that is the provision of law, because the new act would come into play. But anyway, Lordship, what has happened? This award was apparently passed in 1910-2006. This award statement. Thereafter, certain sums were given to us. We were not happy with that. We filed a Section 18 application. That is, Lordship, at page 30, annexure 11, where I filed my Section 18 application.
Yes, you have let this go through that.
Yes, I've taken. Then, Lordship, they filed statements as required under Section 19. This Section 19 application, a petition, should reflect on what basis this amount was given. What is the basis they took? Nothing. Absolutely nothing. It's just vague. And that is what was given. No basis whatsoever was given to us at any point of time, or even said by the government advocate. Then, Lordship, we have the impugned judgment at page 123. Our part is at page 1, because two cases were heard together. Our part is at page 146. The claimant
146 of the paper book.
of the paper book, Lordship. Our part starts here. That is the reference case number LA case number 109. It's dealt with here. A number of issues have been framed. Lordship, primarily, we examined 8 witnesses. The government side did not produce any witness at all, nothing to justify the basis Then, Lordship, a number of issues were framed.
Written statement 5.
Written statement was filed, but there was no evidence in support thereof. So that has no evidentiary value. Now, Lordship, number of issues were formed. The most important issue, which I think should be, I would like to bring to Lordship's notice, is issue number 3, whether the award made by the collector for land according to the prevailing market rate, if so, is the award justified and reasonable. Then, Lordship, the issue number 3 has been discussed at page 149. Lordship, our
This is
case, page 149, issue number 3 is has been discussed.
Yes.
Lordship, I will just take your Lordship. The claimant has pleaded that the claim has been submitted in written argument as per the valuation statement, paper mark 5, and the compensation of the acquired land has been assessed at rupees 240 per square meter along with 30% solatium amount and interest at 12%. Whereas the CW1 and CW2 in the deposition has deposed that the assessment rate by the OP collector is highly inadequate for not considering the prevailing market rate of the claimant's land, which situated at main GS Road at Boridwar, located in the prime industrial area, as many major industries establishments of the state are located there. Thus, the land in the area is priced by the business community of Shillong and Guwahati, having high business potential. For commercial and industrial use or any other purpose, and not only as a relevant time of notification but subsequent years also. On this, the claimant has on this claim, the claimant has relied on the valuation certificate issued by the written CW5, witness CW5, the Revenue Officer, Khasi Hills Autonomous District Council, which was exhibited as Exhibit 1, which it stated that the value of the land of Boridwar this days during the relevant period was 300 rupees per square feet, that is 3,222 per square meter, which value the claimant claims entitled to. Besides, even the headman of the Hemu Myanmar examined as CW8 and Srimati Victoria Walang examined as CW7 had also corroborated CW1, 2 and 5 on the value of the land, equivalent to be acquired to be at rupees 300 per square feet, this is 3,222 per square meter at the relevant time of acquisition, by stating further that the present market rate of the value of the land is about 400 to 450 per square feet, located at main GS Road. To the contention, Lordship, then on this contention, we have produced the statement of CW1, who says it should be 300 as per this, and then CW5, which is the Revenue Officer, that is at page 35. I'll just take Lordship to page 35. Page 35, that's the Revenue Officer.
Page 35.
Page 35, that's his evidence.
Next 14.
Yes, S35 is the certificate issued by the Revenue Officer. This is a valuation certificate, with this has been exhibited also. There's no quarrel about that. With reference to the subject cited above, I am to inform you that the present market value of your land at this measuring nil more or less per schedule described below is 300 rupees only per square feet. That is what similar land, my neighbor's land, he gave this, the revenue officer gave this certificate. What he said, he made no assessment. On the basis of his knowledge, being the revenue officer, he gave that this is the going rate. Now this is again supported by PW8, who is a village headman. PW8 Lordship is at page 77. And Lordship, I may also point out this CW3 is not crossed, has not been put to cross-examination. He didn't. The revenue declined. The government declined to cross-examine. Then Lordship will come to page 77, which is the evidence of the headman. This, aged about this, resident of this, say I am the resident of this and I am the Rangba Singh of this village. That the claimant here owns a landed property at Baridwar village and has constructed godown, industry, shed, multi-storied building in the said land, set up a small-scale industry therein with the name of Messrs. SB Industries Manufacturing and Packaging Mustard Oil. The claimant has let out remaining portion of the godown industry sheds to different lessees for earning rent therefrom. The claimant has constructed the boundary wall on the land to safeguard the premises, and the boundary wall was about 119 meters in length and about 3 meters in height. The government of Meghalaya in the year 2006 had acquired the land from Khanapara to Jorabad NH 37 Meghalaya side for construction of a 4-laning of National Highway NH 37. The land and the so building godown industrial shed of the claimant have been acquired under the same. Out of the claimant's total land measuring 6983.24 square meters, about 2072 square meters had been acquired. After acquisition, the claimant's land has become inaccessible from the proposed national highway, as the land being cut off for making highway. The proposed 4-lane way is at a level 15 feet lower than the lower level land, and this diminished the value of the land. During the acquisition, the industrial estate's multi-storied building has been partially demolished, which has been built, rented, and the remaining portion of the industrial estate go down building as practically unused and valueless. The rest have become unused and valueless. So this is that Lordship will come to para 7 again. The going market rate at Baridwar this in the year 2006 was acquired by the collector for 4-laning was 300 rupees. 300 rupees per square feet valuation of the land around the area where the land has of the claimant is situated at time of acquisition, and was not less than 300 rupees. I know this because I'm the headman of the village at that time, and when the land was acquired by the government, present rate of the land of the locality somewhere between 400 to 450 per square feet, and construction of the in view of the construction of the 4-way lane. So this is it, and he has also been not crossed. So the evidence of the CW3 and CW8 CW 5 is 5 and CW8, they are unrebutted.
Yes.
They have not been put to cross-examination. Now, Lordship, even the tenants have come forward and give their evidence. That is CW3 and CW4. These are the tenants. They say that we had rented out, we had taken this on rent, and one paid 30,000 and one paid 80,000. This is what is there in their evidence. Cross has been declined. Their evidence stayed. This is what they have said. I can, if your Lordship wants, I can take Lordship to the evidence, or is it?
I don't think it's necessary. You have not said anything about the price
Beyond
or
the records,
valuation.
beyond the records, nothing. So CW5 and CW3 and CW4, their evidence also stands unchallenged, unrebutted. Now, Lordship, the neighbor also, that is CW7, she also says that the revenue officer of the district council had issued me this certificate, and the value has been said to be 300 rupees per square feet, not put to cross. Now, Lordship, if your Lordship comes to the impugned judgment, the evidence of the CW5, that is a revenue officer, that's at page 153. 153, no? No, where is the quote? No. That 149, Lordship, there where he discusses the reference court.
That you have
151, the reference court relied on the judgment of this court in the case of Modi M. Sangma versus the Garo Hills Autonomous and others, where it observed that the district council is not the authority to, Lordship will find at page 151,
yes.
is not the authority to assess the value of the land acquired as per the said rules, as Assam and Meghalaya districts rules, and do not provide for any position under the district council court to assess the value of the land acquired under this. Hence, they say that in that case the assessment was done by the revenue authority of the district council. So court said that you have no business to assess the land, and said, applying that analogy to my case, say they rejected the certificate issued by the CW5. But may I just make a distinction? The certificate which has been issued by the CW5 in my case is not an assessment. He just says that this is the rate which is going. He has done no assessment, nothing, absolutely nothing. And then again, they relied on 1995 Supreme Court, page 840, para 7, where they say that initial burden of discharging, that the amount of compensation is inadequate, is on me, on the claimant. It's only then that the...
What was the citation again?
1995 Supreme Court, Supreme Court, page 840. I'll just give a copy of the citation to your Lordship. So that is what they relied on page 7, paragraph 7. He realized paragraph 7. When collector makes a reference to the court, he is adjoined by section 19 to state the grounds on which he had determined the award of compensation if the objection raised as to the acceptance of the award of the collector under section 11 of the by the claimant was as regards the amount of compensation awarded for the land under this. The collector has stated that the grounds on which he has determined the amount of compensation which was where objections were raised by the claimant in his application for reference under section 18 was inadequacy of the compensation allowed by the award under section 11 as required under subsection 2 of section 18 itself. Therefore, the legislative scheme contained in section 12, 18 and 19, while on one hand entitles the claimant not to accept the award made under section 11 as the amount of compensation determined as payable by his of his acquired land and seek reference to the court for determination of the amount of compensation payable for the land, on the other hand, requires him to make good before the court the objections raised by him as regards the inadequacy of the amount of compensation allowed for his land under the award made under section 11, with the view to enable the court to determine the amount of compensation exceeding the amount of compensation allowed by the award under section 11, be it by reference to the improbabilities of inherent in the award itself and on the evidence adduced by him to the effect. That's why the position of the claimant in a reference before the court is considered to be that of a plaintiff in a suit requiring him to discharge his initial burden of providing that the amount of compensation determined in the award under section 11 was inadequate, and the same not having been determined on the basis of the relevant materials by application of the correct principles of valuation, either by reference to the contents of the award itself or with reference to other evidence adduced before this court. Therefore, if the initial burden for providing that the amount of compensation allowed by the award of the collector was inadequate, it is not discharged, the award of the collector is made final, the conclusive evidence under section 12, regardless of the matter containing therein, will stand unaffected. But if the claim succeeds in proving that the amount determined under the award of the collectors is inadequate, the burden of proving the correctness of the award shifts to the collector, which has to adduce sufficient evidence on behalf to sustain such award. Hence, the court, which is required to decide the reference under section 18 of the Act, cannot determine the amount of compensation payable to the claimant for himself exceeding the amount determined in the award made under section 11 for land unless it gets over the finality and conclusive evidence value attributed under section 12 by recording the findings of consideration of the relevant materials that the amount of compensation determined under the award was inadequate for reasons weighed within. Now this they relied on and dismissed my said I have not discharged my duty first initial burden. So, and then he goes further to say that acquisition as per law, when they do not produce such sale deed or agreement to sale for similar type of area near the cannot be taken into consideration. That is what they go on to say that. But sale deed is the best evidence. But if you do not have a sale deed, I can produce other evidence to show what is the value of it. It's nowhere on record, nowhere, none of the decisions that the courts say that you have to produce the sale deed only, and unless you produce a sale deed, we cannot, vary the award. Now, suppose in an area where no sale has taken place, Lordship will go either by the government value or what is the going value which I would offer or someone is willing to buy. That is all. That will be determined by circumstantials. What the area is not necessarily sale deed, but what the land would fetch, depending on how developed it is, where it is located, everything. And this is on GS Road. Obviously, the value is high. Now, on these two grounds, the certificate was rejected, and the court held that I have not put nor discharge my initial burden, which is not correct. I have given evidence which is unrebutted. And if Lordship looks at this decision itself, 95, there are a number of, even paragraph 5 really says, no such. 5, it says that the collector shall determine the award. The collector, section para 5, it says the collector is required to make an award as the amount of compensation payable.
Para 5.
Para 5, Lordship.
The amount of compensation?
The amount of compensation, Lordship, will come between placenta F. However, when no such agreement is reached, the collector is required to make the award as to the amount of compensation payable for the land as required by subsection 1 of section 11, being guided by the provisions contained in section 23 and 24 as we says by section 15. Now, whether the collector has done this. From the Lordship, collector has not referred to section 18 at all, section 23 at all. If Lordship looks at the award, he talks about the land value, amount of compensation, then Lordship will come at with amount of compensation allowable for damage under 6 of 23.
You're
nothing.
Reading?
The award is very clear.
What?
He has not taken into consideration the factors mentioned in clause 23 of the Land Acquisition Act. Section 23 of the Land Acquisition Act 23 has laid down certain parameters which has to be taken into consideration. The section 23 first talks about the market value. Second, the damage sustained by the persons interested by reason of taking any stationary crops, that he has put in head there, Lordship. Damage sustained by the person interested at the time of collector taking possession of the land by reason of severing such land from his other land. Mine only part is done. So my land has been severed. So I have sustained the damage, and CW3 clearly says that now the road is 15 feet below. Mine is 15 feet high, so I don't have accessibility. So my plot has been adversely affected. Where is the consideration for that? There's no consideration. Then Lordship will come to fifthly, the acquisition. In consequence of the acquisition of the land by the collector, the person interested is compelled to change his residence or place of business. I have been compelled to change my residence, place of business, Lordship. That is on record. I had a mill. My son had a mill, the claimant number 2. And that we have put on evidence. That has not been, on that part there is no cross. They have crossed claimant number 1 and 2. But that on that factum, that I had a mill there, I have a registration which I have proved, and that I have to shift my business, change my business. On that, there is no cross, and there is no whisper, and no compensation whatsoever has been awarded. And sixthly, the damage any resulting from diminution of the profits from the land at the time of publication of the yes, Lordship. I had tenants there. My tenants have come forward, given evidence which is unrebutted and accepted to be correct. So I have lost about 80,000 rupees a month, which has not been taken into account in the award which has been passed by the Deputy Commissioner and in calculating the compensation. So these flaws exist on the face of it. It exists, Lordship. And then again, when it comes to structure, I have my CA giving the structure, giving the assessment. He has the architect, and then the architect's evidence has been rejected, Lordship. on the ground, which is issue number. Lordship, at issue number 6 is regarding the business laws, I think. Issue number 6 is issue number 6 is regarding the height of the various portion of building, whether the claimant entitled to compensation calculated on pro rata basis as per square meter, and if so, that is what then Lordship will come. That is issue number 6 is at page 156, where it is said that that the claimants have adduced as claim. And there I have given the evidence of the architect. Then CW6 is Pranab Chalia, the engineer architect, under whose supervision the claimants claim they have constructed the building, who deposed the dimension of the various constructions were stipulated above and stated table 5 discerning the portions. The CW1 further deposed that the OP number 1 had acquired a building having a plinth area of this much on the ground, but not have paid compensation only for the acquired portion of the building, calculated the compensation for a single storied building. There, at some portion of the building were double storied, and some of the portions were having height ranging 3.6 meters or 5 meters.
You mean to say that this whole exercise was not carried out by the
all exercise was not carried
the
out.
collector?
That is my case.
They should have assessed your
My
the value of a building.
Now they question, do I have the permission? You have paid for some portion. If you now cannot go back and say, do I have permission for constructing this shed, when you yourself paid for a portion but not for the entire thing. And after that, how can you say this is what has been done? Now Lordship will come. I will not take much of Lordship's time. Lordship, I have taken Lordship through the evidence. Now I'll take Lordship. They have filed a WS, the Deputy Commissioner, but no evidence have been given in support thereof. Now, reference court is not a court of appeal, Lordship. It is a court where you decide all the issues and you are supposed to put your evidence forward. The collector did nothing. No evidence, nothing. He just made, in fact, in the argument, I think, in WS he said that the PWD rates. Now, what are the PWD rates? Have you come and said that? No. And WS without that has no meaning. I'll just place a decision before your Lordship that WS, which is not for a... Sorry, not that. WS one. No, that is not the one, Lordship. I'll just give another one. Very short it was. Paragraph?
Well, let us go to the WS. What are the averments made there?
Lordship?
What are the averments made in the WS?
In the?
WS.
WS.
What's the WS?
I'll just say. Page 90 by the collector. Page 90, Lordship. A one page. The claimant has no locus standi filed the case against the answering opposite party. The claimant claim for enhancement of the claim in the case is highly exaggerated, fantastic and unreasonable and illogical. The answering opposite party number 1 has no comments to make on the statements in paragraph 5, 6, 7 of the claim, that the statement of the paragraph 1 to 2 are admitted, while those in paragraph 3 to 4 are not admitted, hence denied. The claimant opposite party number 1 follows that the statement in paragraph 3 is denied. The collector who assessed the rate had taken into consideration all the records available, hence hence 240 per square meter is fixed as per the prevailing market rate. Mention may be made that the person interested could have produced documents showing that the rate was more than 240 per square meter. The Public Works Department building prepared the assessment, etc., of the affected building, out of which additional 30% solatium and 12% interest being compensated as per stipulated under the claim petition is liable to be rejected. Now this is all. Nothing,
Where are the supporting documents?
nothing, Lordship.
No documents.
Nothing. No evidence have been laid. No evidence have been laid.
Along with your WS, along with your WS or plain, you are supposed to file your set of documents.
Correct. Nothing is there. And even thereafter, even if you file Lordship, I have to give my evidence.
True. That is
That is granted. Now, no evidence have been given. No cross has been done except 1 and 2, which is a vague cross, which one question they asked, I think in CW1, do you remember what is the rate? She said, I don't remember. That's it. And then those, the document, the certificate which I gave, that has not been questioned. Only now said that as per the high judgment of this honorable court, that assessment cannot be done. That's not an assessment, Lordship. A plain reading would say that this is a value. And what about the evidence of the headman? That is not been put to cross. So that stands. So in base of all this, so the value obviously is 300 rupees per square feet. That is what should be the value of the land. And even the building, how you have done, what basis, what you have taken. I have given my architect's drawing. You do not rely on that. After that, Lordship, what remains? This calculation as per 300 rupees per square feet and the architects, that has been done. Boundary wall they have given us compensation. And Lordship, 240 per square meter is a ridiculous amount of compensation, and you know where it is. So how can the reference court committed grave illegality in rejecting all and saying that they are not acceptable, you do not have a sale deed, and revenue authority cannot assess the land when he is not assessed, and except the case of the deputy commissioner, when the deputy commissioner, the collector, when he has produced no evidence on record, nothing, no documents in support of his case, and just accepting the award and putting a stamp of finality to it. Because a reference court, Lordship, is not a court of appeal. It has to look into everything. In a reference court, you are more like a suit which comes up.
It would be a court of the first instance.
Yes, Lordship. Lordship, this, I think 1998, at paragraph 4, I will just... 1988, page 3 SCC, page 751, paragraph 4, the factors to be etched and mentioned in the mental screen when taking an application under section 18. A reference under section 18 of the Land Acquisition Act is not an appeal against the award, and the court cannot take into account the material relied by the learned acquisition officer in his award unless the same materials is produced and proved before the court. It's very clear, Lordship. So the award of the land acquisition officer is not to be treated as judgment of the trial court, open or exposed to challenge before the court hearing the reference. It is merely an offer made by the land acquisition officer and the materials utilized by him making his valuation cannot be utilized by the court unless produced and proved before it. It's very clear, Lordship. The court has to treat the reference as the original proceedings before it and determine the market value afresh on the materials of the basis of the materials produced before it. The claimant.
So these are the parameters.
These are the parameters which has been laid down. So these parameters have not been followed by the reference court, because the deputy commissioner cannot say, this is what I did, this is my written statement, I have done this. In view of this itself, this reference has to go. Now the question arises, what will the Lordship do? Whether the Lordship will hold the evidence which I put forward as the which are unrebutted.
You see, if your argument is to be accepted,
Yes.
is there a provision for a remand
I do not.
or retrial?
It's a regular civil appeal.
No, it's not an appeal.
It's
not
it's
an appeal.
The provisions
This
of the
is an
CPC apply, so therefore lordships have the power to remand. There are other instances where remand have been permitted.
No, this is an appeal, but reference court is not. Yes, there is a provision.
What he's saying is correct. This court is the appellate court.
Lordship may remand it back if Lordship deems it fit.
That is, see, that is on. See, that is what you say. We'll have to hear the other side.
Yes. And Lordship, I have a number of judgments. I can place that also, or I can place at the time of closure. On these points only. On these points only.
But have you given them a list of your?
I'll give a list of. This is the WS without evidence, Lordship. I will just give that. 2024 SCC online. That is any averment made in the plaint or.
Just move.
I've given Lordship a copy of that. Any averment made in a plaint or written statement must be supported by evidence. In absence.
What is the citation again?
Citation is. I've given a copy to your Lordship. Now 2024 SCC online.
This one.
Online Supreme Court
3851.
3851. Lordship, paragraph 16. We find that any averment made in a plaint or written statement must be supported by evidence.
Just a moment, just a moment.
Paragraph 16.
Yes.
In absence of there being any evidence, the first appellate court could not have implied that there was already evidence in regard to what has been stated in the written statement, and without recording any evidence in support of the amendment pleading. There was an amendment, but whatever it is, this is a clear, has to be supported. So here it has not been done. And Lordship, there's one more decision I will place before your Lordship. 2016 12 SCC, that is at paragraph 14-15. It's settled law. Denial for want of knowledge is no denial. The execution of a sale deed, and Lordship, I will not do. The provisions contained in Order 8, Rule 5 requires pleading to be answered specifically in written statement. The court, then Lordship will come. Moreover, there is no effective cross-examination made on the plaintiff's witnesses with respect to the factum of execution of the sale deed. PW1 and PW2 had not been cross-examined as to the factum of execution of the sale deed. Cross-examination is a matter of substance and not procedure. A procedural one is required to be put one's own version to cross-examination of the opponent. The effect of non-cross-examination is that the statement made of the witness has not been disputed, and the effect of cross-examination of the witnesses has been considered by this court in this, and the court has repelled the submission on the ground that the same cannot be put either to the witness or suggested before the court below. Party is required to put his version to the witness, and if such questions are put to the court, would presume that the witness account has been accepted. If you fail to cross-examine, that means accepted the account of the witness. So here, on the most valid portion, that how my 23 has not been considered, which is the mandate, you couldn't go. Deputy Commissioner not given, not produced any, the collectors not produced anything before the trial court. So that judgment comes in. In view of this, the reference judge cannot stand.
Yes, Mr. Sen.
Well, I may be permitted to reply
done.
tomorrow
I have done.
or day after, my lords. I may be permitted to reply day after tomorrow. Because there's anyway shortage of time. I'll take a little bit of time in this matter.
Next week.
Next week, Lordship.
Lordship, a date may be fixed.
You suggested it.
Wednesday, Lordship?
No, not on a Wednesday.
Not on Wednesday. What is next week? Tuesday, again.
Lordship, I may be allowed to file objections also, Lordship, cross objections.
Why?
To what?
Lordship, on the...
Who are you?
I am for NHI, Lordship, the beneficiary.
Okay.
Lordship, here, since the award is not made in a proper format also, with regard to that, Lordship, I may be allowed to file my cross objections on. Because the award copy of the award was received during the reading, the trial in the...
But you should have said that a long time ago. This matter has traveled, you see, to this level, where hearing is already completed. You are the beneficiary. You are the authority which has
To make the payment.
made the payment. True, you have to be heard, but in the way you have appeared in the proceedings, I know.
Lordship, on last occasion also, I tried to make my submission, but since I am the only beneficiary, I am the beneficiary in this case. Lordship, the main and moreover the award copy, the Lordship was awaiting for the award copy also. So, Lordship, after receiving the award copy, I found that the award is not in a proper format, Lordship. So I may be allowed to file one objection or short objection, Lordship.
Lordship, then I may be given a
Just a moment.
response.
I don't understand.
Now, I believe what my friend is trying to say, they want to file a cross objection, my lord. That is available to them, as and when they want to file.
True, that can be done.
But then I must be given a chance to respond.
No, you have to.
I have to
But then you see what we are talking now. See, earlier I had made a query when the award was we just produce it
Lordship.
as it is, whether it was brought on record, whether
Exactly. What my learned seniors informed, it is not part of their memo of appeal as well. And they've also mentioned it's not part of the LC records.
it was incumbent upon you to, because the award is yours.
Yes, my lord. yes.
Document
You
is
are the
there,
one who
Lordship,
should
not
bring-
mine.
Again, that's what I'm saying. There's no pleading in the memo of appeal that they never received a copy of the award. There's an oral submission. I'm certain a
it's
copy
not-
of the award was with them.
It's not there. It's not in the records also which you produced.
That we'll have to examine
I
the
didn't
records,
pro-
my lord. But
please
to
do.
say that
Please
they
do
have
an
never
exam-
received a copy, this should have been part of their memo of appeal. They've never said that anywhere.
Appeal, I only give grounds. I don't state facts. I give only grounds, not facts.
There is a huge narration of entire set of facts. Nowhere have they said that they never received a copy of the
What about
award.
the reference court? Why did you not
That cannot be
produce-
accepted, my lord.
Why did you not produce in the
Is
reference
Lordship
court?
requiring us to file an affidavit to bring this on record?
You have to then. You have to.
Let them give.
We can-
Lordship, this is a...
Now, if she wishes to file a cross objection
Lordship.
based on the award
award.
or the
So
statement,
that is
statement of the
for
award,
that is for Nahai. If at all they want.
that's for
Lordship, did the collector ever come before the revenue court and even produce the award? This is the award. It is done so beautifully, taking everything. Did they ever come and do that, Lordship?
but
They
it's
did.
for you to point that out.
I pointed it out now. I'm pointing
Look at
out
the
now.
grounds of appeal, my lord. These are all oral submissions. Not a single ground taken anywhere.
Yes.
Why, it's a,
Where is the
these-
ground, my lord?
These are questions of law.
No, my lords. Where is the ground?
These are questions of law.
Now there's a mixed question of fact whether the award was actually produced before the court or not. There is no ground anywhere.
Assuming award
no
is
ground
not
anywhere.
produced. Assuming award is not produced. Production of award does not improve the case of the collector. Neither
that
does
I
it-
will extend submissions,
neither,
my lord.
neither does it
No,
demolish my case.
That is beside the point. What we are looking here
My lord.
is the procedure. Whether proposed procedure was followed, whether it's
Absolutely.
it's incumbent upon the parties to do
Absolutely.
so, and whether this court has to look into that aspect of the matter.
Absolutely. So whether court will only look whether the procedure has been
Everything has to
followed.
everything has to be weigh and balance.
Absolutely. And what I'm saying is from the records only as
True.
in the reference court. Nothing outside the record. And in fact,
if you say you have not received copy of the words, so be it.
and Lordship, in the in my statement, evidence also, I have said all we were given was a valuation sheet. That I made a clear statement on that. Now he should not come and make.
No, but they could have
This-
insisted,
he
give
is
me a copy of the
state.
award.
He is a state, Lordship. State should talk responsibility, and state should work for the
responsibility lies on us and
the
nobody
welfare
else.
of the people, not to deprive the common citizens of their dues. That should be the motive with which the state functions.
Lordship, I will satisfy my lords that we have a good case. I'm not trying to improve any case. On the basis of whatever we have, we will make out a case.
No, that,
On record. On record. Next date, Lordship.
no, but what do we do now?
So, my lords, on Lordship's taking it up next week.
You do one thing. We will accept it that the award was not produced before this court.
Lordship.
We'll have to go to the the lower courts, trial courts,
Trial court records.
to find out if it's there or not. Whatever the case may be.
Lord.
So you have brought it today.
My lord.
Bring it by way of an affidavit.
All right, very well.
And if the appellant has any thing to say on it, you can file.
Absolutely. I can
You
make
can
my
file a
answer.
count to that. Similarly,
How long will
file.
it take, Lordship?
1 week.
I will take it just about 2 days to file the award.
2 weeks you took to produce the award.
So we'll do it. Fix it on Friday.
This Friday? For filing the affidavit. Lord.
File
This
it.
Friday. Filing the affidavit. Then the date of hearing
Then
will
the
be
date of, then the date of then the time for your.
No, what I'm saying, let this come up next week itself. In the meantime, I'll file my affidavit to bring it on record and I'll extend my arguments as well on the next date.
And what about NHRM? Not thereafter. Do it simultaneously, Lordship. How can it go on?
That is true. No, we'll do one thing. We'll fix the matter after 2 weeks. 17, 18.
5th of July, Lordship.
5th of July. Who will come?
Sorry.
I won't be available, my lord, 5th of July.
No, it's a Saturday anyway.
And I will.
3rd of July.
I'll also not be available.
Nobody will be available.
3rd of July, Lordship.
3rd
I
of
looked
July,
at the June calendar. 3rd of July.
Okay, 3rd of July. In the meantime, Mr. Sen,
Lordship.
you file your affidavit.
I'll file my affidavit.
Give an advance copy to
Yes,
them.
yes.
And they also can file their objection, whatever.
Lord.
And then by 3rd of July, everything should be on record.
And done and dusted, Lordship.
Not done and dusted. Till the fat lady sings.
Obliged, Lordship.
Heard Ms. Jubdar Leonard, Senior Counsel for the appellant. Hearing on the at night. Stop. In the meantime, Mr. S.N. J. has submitted that, has produced copy of the award as far as the case of the parties is concerned. Copy of where's that award?
Just open it.
Copy of the award statement of LA case number 5 of 2003 pertaining to the case of the parties herein. It is the submission of the learned counsels across the board that the said award statement has not been brought on record in these proceedings. It is prayed that the same may be allowed to be brought so by way of affidavit. Next. In such a situation, the learned senior counsel for the appellant as well as Mr. E. Saji, appearing for the respondent, National Highway, NHAI, has submitted that may be allowed to file a response to the said affidavit if so required. Accordingly, as prayed for, let the collector file the said affidavit with advance copy to the other side, to all concerned, within 1 week from today. The said response, if so, is to be placed on record before the next date fixed for this case. As agreed to by the parties, this is matter on 3rd July.
May I just point out something? Since this is the first appeal, I can bring it on record. Ideally, it should be for the appellant to bring it on record under Order 41, Rule 27, and for lordships to examine. The other thing is, even if I bring it on record, the question of them filing responses may be a questionable issue, my lord.
No, on the award.
Again, we're not challenging the award here. I'm bringing it on record. But then again, in a first appeal, the question of responses will not arise.
It's a matter of record.
I'll not file
What my
any.
friend is suggesting, from what I understand, she wants to file a cross appeal. So that's a different issue. Cross appeal against the
Because not as far as
not against the award. Cross appeal against the order of the trial court.
But isn't
That's
it
the
too
issue
late?
here.
Isn't it too
No, I think the language of Order 41, there is some provision from the first day of hearing. Anyway, that's up to their case. It is their case. It is not my case. The lordship will examine the merit. But the only thing is, when a document is brought on record, ideally, upon discovery, it is for the appellant to bring it on record under Order 41, Rule 27. But the question of responses may not be. It means
No,
questionable
response,
exercise.
I'm not filing it.
All
I
right,
have done
then
my
it's fine.
argument. Even without you bringing
That
on
is why
record.
I said,
Yes,
you see, I've used the language if any.
Yes. All right. It's only for them, I suppose, to file whatever they're choosing to
Then
file.
you have to, as far as he is concerned, you have to change the language of the order.
My lord.
So I want to make a motion. Ms. P. Buchari, letter counsel for the respondent, National Highway Authority, has submitted that she may be allowed to file a cross appeal as far as the impugned judgment of the learned special judicial officer is concerned. The same is allowed to be filed, if so permitted under the relevant law and provision, law and procedure. This is matter on
3rd July, my lord? Highly obliged.
Item number 4.
Ini agak senang hop ni tu.
Please, your lordships. Lordships, I'm seeking lordship's indulgence in this matter for today, lordship. If lordships may have this matter anytime this coming week, lordship, subject to your lordship's convenience.
What?
Yes. Should I?
In fact, they're supposed to start with the main.
Yes, they have to.
No, what do you say? Any objection?
I would not have any objection, your lordship, but only.
Because according to me, everything become infructuous. Though they want to start with regard to something custom, I don't know.
You keep saying that. We looked into it, but the matter has to be heard.
It has to be.
It has to be heard, your lordship, because there is a dispute, your lordship. There is a dispute.
Whatever the case may be, the petitioner will have to make out their case.
When tomorrow?
We'll listen after 1 week.
Lordships.
Ms. Learned Counsel has, for the petitioner, has sought for accommodation on what ground?
Lordships, some more time to prepare the matter, Lordship.
Since she's not prepared for the matter, to be heard in the matter today.
So after warning, Lordship, may not be on 24th, I'll be out of station.
On?
On 24th, I'll be out of station.
So we'll have it on 23rd,
25th, it's okay.
25th,
25th. Or 25th, again, DV will be.
26th, eh?
26.
26.
All right, 26.
26?
Lordship,
As prayed for, this is matter on 26.
highly obliged, Lordship.
Item number 5.
Lordship, if can, this matter may be fixed next week, Lordship.
Why? Look at the last one. What does it say? It says, on prayer made by the parties.
Lordship.
This matter is listed today.
Lordship, the senior counsel is on next before other court, Lordship. Otherwise, my senior can start, Lordship.
I can start. Will not be over.
We'll continue next. You start.
Yes.
We'll see if time permits.
Lordship, at the very outset, this is you have come before this honourable court against the order dated 15/6/2023, which is at Annexure 1, page 20 to 35. And before page 20 to 35, Annexure 1, page 20 to 35. Since my colleague, who is for the respondent, is not here, I may take the liberty, Your Lordship, to just enlighten, to draw Your Honour's attention to Annexure 1, the order passed by the Learned Lower Appellate Court. This is in the court of Srimati So-and-so, District Judge, Riboy District, Nongpor, and State of Meghalaya, represented by so-and-so versus so-and-so. And I'll come to the operative part of the order, Your Lordship. The instant miss case is in respect of the application for continuation of delay.
Page?
That is at page 22, Your Lordship.
22.
This is the operative part of the main.
Para?
No, I'm starting from number 1, Your Lordship, page 22.
Yes, page 22, yeah.
In the instant miss case.
Letter counsel submits delay in proving. Oh, this, you see, how have you made your
Ulta.
Your pagination?
Ulta, Your Lordship?
Ashley.
Very sorry. So it has become page 23.
Should have been careful.
Maybe through oversight, Lordship.
Yes, please.
The instant miss case is in respect of the application for continuation of delay of 707 days in preferring an appeal against the order dated 16/2/2016, passed by the Court of the Assistant to Deputy Commissioner in miss case number 12(T) of 2014, arising out of money suit number 8 of 2014, filed by the applicant, who is the respondent here, Your Lordship, After the respondent entered appearance through the learned senior counsel and filed a show cause on 14/6/2018, the case proceeded for hearing for quite a number of dates as per reasons stated therein in the order sheets. Heard learned counsel Mr. So-and-so for the petitioner who submits that this application for continuation of delay of 707 days was being filed in preferring the appeal against the order dated 16/2/2016 passed by the learned assistant to DC in Miss Case number 12T of 2014, arising out of money suit number so-and-so, whereby the learned assistant to Deputy Commissioner Nopo has held that the plaint in money suit number 8 of 2014 does not disclose a cause of action. The plaint suffers from a defect of non-joinder of parties and that the suit is barred by law, and consequently rejected the plaint in MS number money suit number 8 of 2014. The money suit was instituted for recovery of an amount of rupees 8 crores from the respondent who had fraudulently claimed themselves to be the owner of land and trees in the plot of land situated at Maupalai, Ribhoi district, Meghalaya. The respondent defendants duly entered appearance in money suit number so-and-so and thereafter filed an application being Miss Case number 12T of 2014 under Order 7 Rule 11 of the Code of Civil Procedure for rejection of the plaint. The Learned Trial Court wide order dated 16/2/2016, your Lordship will have to go back perhaps a page, allowed a said application and rejected the plaint in MS number so-and-so. Learned Counsel submits that the delay in preferring the appeal was initially due to the fact that after obtaining the certified copy of the impugned order dated 16/2/2016, the same was forwarded and was received by the Forest and Environment Department on 5/4/2016. The matter was processed at the level of the Forest and Environment Department and forwarded to the Department of Law for advice and legal opinion on 15/4/2016. Thereafter, on 21/4/2016, the Law Department opined that an order of the Assistant to Deputy Commissioner can be appealed before the Court of Additional Deputy Commissioner or District and Session Judge, Ribhoi District, and accordingly advised the Forest and Environment Department to contact the government pleader or any other advocate for drafting necessary appeal. On 13/5/2016, the Forest and Environment Department, after consultation with the Law Department, decided to seek legal opinion from another counsel on the matter. The said counsel, in his legal opinion dated 13/5/2016, opined that a writ appeal should be filed before the Division Bench of the Honorable High Court against the judgment and order dated 17/2/2014 passed by the learned single judge in WPC 299 of 2012, bringing all facts of the instant case to the notice of the Honorable High Court and also to pray for investigation by a neutral third party to remedify the entire situation. The Forest and Environment Department, after obtaining approval from the Law Department on 18/5/2016, decided to appoint the said counsel as special counsel to appear on behalf of the Forest and Environment Department and to prepare and to draft a writ appeal against the judgment and order dated 17/2/2014 passed by the learned single judge in WPC 299 of 2012. On 25/5/2016, the said counsel was appointed as a special counsel for Forest and Environment Department. Just for a moment, I may pause here, Your Lordship. In fact, para 4 and 5, in fact, it's something relating to a writ appeal against the order of the learned single judge. The writ appeal was heard by Your Lordship along with Honorable Chief Justice then. That's a different issue altogether. How they are complicating by bringing it here in this matter before the lower appellate court. I may continue. On 8/6/2016, the Forest and Environment Department forwarded the comments and grounds for filing writ appeal. The learned counsel then prepared draft of writ appeal along with application for condonation of delay and forwarded the same to Forest and Environment Department on 12/7/2016. Thereafter, the Forest and Environment Department forwarded the draft writ appeal to the concerned branch for verification and vetting of the correctness of factual aspect in the writ appeal. After verification and vetting, the Forest and Environment Department then forwarded the approved memorandum of appeal to the Learned Counsel on 8/7/2016. Now, Learned Lower Appellate Court, Your Lordship, perhaps was a little bit confused with the submission of the Learned Respondent, because the Learned Lower Appellate Court was dealing with the appeal filed by the Forest Department against an order passed by the Assistant to DC. Nothing to do with writ appeal, Your Lordship. That's why I'm before this Honorable Court. I'll continue, Your Lordship. The writ appeal, along with a connected application for condonation of delay of the impugned judgment and order dated 17/2/2014, were filed before the Honorable High Court of Meghalaya on 27/7/2016. And the same was registered as missed case (WA number 66 of 2016). The delay in filing the writ appeal was condoned, and the said appeal was registered as writ appeal number 20 of 2021. The said writ appeal number 20 of 2021 was heard and disposed of by the Division Bench of the Honorable High Court of Meghalaya by judgment and order dated 9/2/2022. The Division Bench of the Honorable High Court of Meghalaya primarily dismissed the appeal, in fact filed by the Forest, Your Lordship, Department, on the ground that the applicant herein, the appellant in writ appeal, cannot be regarded as person aggrieved by the impugned judgment and order dated 17/2/2014, passed by the learned single judge in WPC number 299 of 2012, as the applicant have accepted the said judgment and order dated 17/2/2014 and have accordingly filed the money suit in question, suit number 8 of 2014, for recovery of money. The applicant, after considering the seriousness of the matter, again decided to seek legal opinion from a senior advocate in the matter. The learned senior advocate, adverting to the facts that no appeal has been filed against the order dated 16/2/2016, passed in missed case number 12T/2014, tendered an opinion that an appeal must immediately be filed against the order dated 16/2/2016, passed in missed case number so and so, even though a writ appeal has already been filed against the order dated 17/2/2014, passed by the learned single judge in WPC 299 of 2012. On 11/1/2018, the Forest and Environment Department, after obtaining the approval from the Law Department, appointed the senior advocate as special counsel to appear on behalf of the Forest and Environment Department and to prepare a draft appeal against the order dated 16/2/2016, passed by the learned trial court in missed case number 12T of 2014. On 12/1/2018, the Forest and Environment forwarded the comments and grounds of filing the appeal to the senior special counsel and requested the counsel to prepare a draft of appeal along with application for condonation of delay. The learned counsel then prepared a draft of appeal along with application for condonation of delay and forwarded the same to Forest and Environment Department on 25/1/2018. Thereafter, the Forest and Environment Department forwarded a draft appeal to the concerned branch for verification and vetting of the correctness of factual aspect in the appeal. The Forest and Environment Department then forwarded the memorandum of appeal to the learned senior counsel on 13/2/2018 for filing in the court, and the same were filed before this court. That is before the lower appellate court, Your Lordship. Learned counsel further submits that a certified copy of the impugned judgment and order dated 16/2/2016 was received by the applicant on 5/4/2016. As such, counting from the date of passing the order, the appeal ought to have been filed on or before 16/3/2016. Counting from the date of knowledge, the appeal ought to have been filed on or before 5/5/2016. However, due to the circumstances as stated above, the appeal could be filed only on 23/2/2018, thereby a delay of 707 days has caused, if counted from 16/2/2016, and a delay of 658 has been caused if counted from the date of knowledge, that is 5/4/2016. Learned counsel submits that the delay is not intentional but due to the circumstances as stated above, which was occasioned due to the bona fide relief that the remedy of filing a writ appeal against a judgment and order dated 17/2/2014 passed in WPC number 299 of 2012 was the proper remedy. It was only on the legal opinion tendered by the senior special counsel that the applicant realized that the proper remedy is to file an appeal against the order dated 16/2/2016 passed in Miss Case number 12T 2016. Learned counsel also submits that the applicant has been diligently pursuing the matter and the Forest and Environment Department is an impersonal machinery acting through its officers, servants, after obtaining legal opinions from government councils and appropriate special counsel. The decision was taken and approval obtained through the administrative hierarchy on the basis of the legal opinions of the government council and the special government council. The matter involves recovery of public money of rupees 8 crores from the respondent, which the respondent have fraudulently collected from the office of the collector, the Void district, claiming themselves to be owner of land and trees acquired in Maupalai village. Learned counsel relied on so will not deal on that, Your Lordship. I come to para 15, Your Lordship. Mr. So-and-so, learned senior advocate for the respondent, on the other hand, began his argument by stating that the appeal is barred by a delay of 707 days and a condonation of which has been sought through the instant Miss Case. That the judgment and order dated 16/2/2016, which was appealed against, has been passed after notice was duly served upon the state applicants. Thereafter, learned counsel for the appellant applicant has made his appearance on behalf of the state. As such, he is very much aware of the passing of the judgment and order dated 16/2/2016. As per their own assertion, the applicant state has received the copy of the judgment and order on 5/4/2016. Even if it is assumed that the knowledge of the state is to be counted on and from 5/4/2016, there is absolutely no explanation as to how and why it took more than a year for the appellant state of Meghalaya in the Forest Department to forward the file to the Law Department for advice only on 15/4/2017. Even if it is assumed that the said date 15/4/2017 as pleaded in paragraph 5 of the application for condonation of delay is a typographical error, no petition for correcting the error was filed by the applicant, nor any steps was taken for correcting the error until the show cause was filed by the respondent, and as such and such conduct on the part of the applicant cannot be accepted. Even then, there is no tenable reason appearing in the application for the state to show why the opinion of the Law Department dated 21/4/2016 took almost 2 years to materialize when the said appeal said to have been filed on 22/3/2018. The facts pleaded in paragraph 5, 6, 7, 8, 9, 10 up to 15 does not constitute any ground, far less any satisfactory ground for this court to condone the inordinate delay of 707 days. Mere fact of shuttling between departments without plausible explanation for the delay, even if not on a day-to-day basis, cannot be the ground for condonation of delay, more so if the delay is caused by laches. The mere fact that even after the opinion of the Law Department was received on 21/4/2016, the file could be handed over to the Land Council only on 11/1/2018, after obtaining order from the Law Department as pleaded in para 13 of the application, is no ground for condonation of delay. The intervening facts as pleaded in the condonation petition do not constitute any judicial tenable explanation for condonation of inordinate delay. It is settled position of law that the state is not occupying any preferred coveted position than any other litigant when it comes to explanation with the cause of delay. In the instant case, the facts pleaded in the condonation petition fail to arouse any confidence to this court for arriving at judicial satisfaction, so as not to term the delay as laches on the part of the appellant. The statutory period of 1 month cannot be substituted by 707 days on the basis of statement made in the condonation petition of the applicant of the appellant. In the instant case, there is no tenable ground before this court to derive a satisfaction that the cause of delay was inevitable and not caused due to laches. Accordingly, the application for condonation of delay is liable to be rejected. That is our stand, Your Lordship. Lordship will have to rise.
We will continue. When?
Do you want it next week? Let it be next week, Lordship. Any day.
Next week. Mr. PGK Kanta, Legislative Council, for the petitioner has commenced his argument, but will continue the same on the next day. As prayed for, this is matter after 1 week.
This prayer is made by them, Your Lordship. Much obliged, Lordship.
My lord, there's only one matter in Lordship's list, item number 8. My friend is here. He's agreed to have it on some other day. Perhaps if it permits tomorrow, my lord, or any other day.
Not tomorrow.
So any other days, as it is convenient to your lordship. But the only thing is there is a stay order which expires today.
Continue.
That may kindly continue. All. Please, lordship.
We'll see the convenient and pass the
Yes,
orders.
yes.
Could be after a week or so.
Lordship.
Obliged, lordship.
Yeah, please, sir.